Chapter 9, Unit 9, Public Service, Union Public Service Commission, Selection Commission. The work of a modern government in any country is carried on by its administrative agencies. There has been a phenomenal expansion in the functions of the state, and reliance is laid heavily on the organizational and administrative capacity of the government. Sound administrative organization, methods, and procedures, competent public servants devoted to public interest are some of the essential requirements for proper performance of the functions of the present day state. When civil servants occupy such an important role, especially in these days of state assuming overwhelming responsibilities, the important aspects relating to their recruitment, training, emoluments, conditions of service, promotion policies, etc. assume importance. The impartial consideration of these matters relating to civil servants requires an independent and expert authority, the institution of Public Service Commission. In India, Union Public Service Commission occupies an important position in our constitutional scheme, and its relation with the government are complex. It is an independent constitutional body for impartial consideration of service matters of government employees. It has important constitutional functions and duties, but has only an advisory role, while the ultimate authority rests with the government. In a democratic system, the Selection Commission has to strive towards an efficient and economical management and creation of public service, maintaining the ideals of a democratic government. In a welfare state, the objective of service to the people further complicates the task of personal administration. The success or failure of a system is gauged by the ability of the organization in personal management to meet the above objectives. Evolution of UPSC. Development of Public Service Commission in India. Today, the recruitment of civil servants is done by the Union Public Service Commission. The name civil servants was first assigned to those servants of the East India Company who were concerned with the administration of its commercial affairs in India. The servants of East India Company were then selected and recruited by its court of directors in England. For purposes of recruitment, a rudimentary knowledge of Eastern trade and commercial accounts was considered to be a qualification for the candidate. But on the whole, the recruitment was made on the basis of patronage. Since appointments had been exclusively reserved to the nominees of the directors, this led to more corrupt practices in the recruitment of the services. It was early 1933 that Lord Granville, who was then an influential member of the House of Lords, advocated the practice of recruitment of candidates through competition instead of nominations by the directors. Yet nothing was accomplished in this direction till 1853. It was early as in 1833 that Lord Granville, who was then an influential member of the House of Lords, advocated the practice of recruitment of candidates through competition instead of nominations by the directors. Yet nothing was accomplished in this direction till 1853. However, in 1833, a clause was inserted in the Charter Act granted to the company declaring that henceforth fitness was to be the criterion of eligibility to the civil services irrespective of caste, creed or colour. The right of the directors to make nominations for appointments to civil services in India was allowed to continue only till end of April 1854. A committee under the chairmanship of Lord Macaulay was appointed in 1854 by Sir Charles Wood to advise on the measures to be adopted to give effect to the Act of 1833, which at least in theory threw appointments in the Indian civil service open to competition without any discrimination. The committee recommended the selection of candidates on the basis of a competitive examination. The requirement of a period of probation before they were finally appointed and the abolition of the college at Haileybury. The system of competitive examination had its first trial on the Indian soil and was then adopted gradually in England, but the process of Indianization of the service continued in a very slow pace until 1909 when the Minto-Morley reforms were introduced. But the reforms failed to satisfy the Indians. First period 1926 to 37, Government of India Act 1919 and Lee Commission. The Government of India Act 1919, which was based on a joint report submitted by Lord Montagu, the then Secretary of State, and Lord Chelmsford, the then Viceroy and Governor General of India, was the first step towards the establishment of a Public Service Commission (PCS) in India. The Act recognized the importance of having a competent and independent civil service. It felt that there is a need for recruitment of civil servants by an expert body without any political interference and establishment of a permanent office entrusted with the regulation of service matters of civil servants. Section 96C of the Act provided for the setting up of a Public Service Commission which was to discharge in regard to recruitment and control of public services in India such functions as may be assigned thereto by rules made by the Secretary of State in Council. The framers of the Act contemplated that the institution of a Public Service Commission in India would help in increasing entry of Indians in the public services and would also provide protection to the civil servants from political interference. According to the provisions of the Act, the Public Service Commission was to consist of not more than 5 members, including the chairman. Each member was to hold the office for 5 years and was eligible for reappointment. The Lee Commission 1923. In 1923, the British government, in pursuance of their declared policy of associating Indians with every branch of administration, constituted a commission under the chairmanship of Lord Lee to inquire into the organization and general conditions of service and also the method of recruitment for Europeans as well as Indians. As it was concerned only with the superior civil services, it came to be known as Royal Commission on the Superior Civil Services in India. The Commission was of the opinion that the establishment of a Public Service Commission was necessary to assist the government in the discharge of its responsibility. It considered that its recommendation regarding the establishment of Public Service Commission as one of the cardinal features of its report and as forming integral and essential part of the whole structure of its proposals for the future of the services. The Commission therefore suggested that the statutory Public Service Commission as contemplated by the Government of India Act 1919 should be established without delay. The Commission was to consist of 5 members. About the members' qualification, it was in favor of their being detached from all political associations and at least 2 of them to possess judicial or legal qualifications. They were to be full-time officers and their emoluments were not to be any way less than those of High Court judges. Another important feature of the Commission's recommendation was that they did not suggest similar commissions for the provinces and held that expertise of the Public Service Commission at the centre should be placed at the disposal of the provincial governments. Regarding the functions of the Public Service Commission, Lee Commission maintained that they might be of 2 kinds. The first was recruitment of personnel for the public service and maintenance of proper standards of qualification for entry to public service. The second function was quasi-judicial, connect with the disciplinary control and protection of the services. The recommendations of the Lee Commission, however, remained in abeyance for about 2 years, and it was in February 1926 that the decision was arrived at by the Secretary of State to constitute a Public Service Commission. It had a chairman and 4 other members. The commission started functioning from October 1st, 1926. It was to advise the Governor General in Council on any question connected with recruitment to All India services. Central services class 1 or class 2. The functions assigned to commission were no more than of an advisory character. The Lee Commission wanted the Public Service Commission to be the final authority as far as recruitment to services in India was concerned. But the Government of India then did not pay any heed to its recommendations, and so the Public Service Commission was constituted only with advisory powers. In 1930, the first roundtable conference was held in London to provide an opportunity to the representatives of different interests in India and those of Britain for evolving an agreed scheme regarding the services and the Public Service Commission. It adopted a resolution that in every province and in connection with the central government, a statutory Public Service Commission shall be appointed by the Governor or the Governor General as the case may be. Proceedings of the Indian Round Table Conference 12th November 1930 to 19th January 1931. 12th November to 19th January. Report of Subcommittee on Series Number 8, London 1931, page 67. The constitutional proposal of the British government, published on 15th March 1933, also provided for the establishment of Public Service Commission in provinces besides the Federal Public Service Commission. The Joint Committee on Indian Constitutional Reforms 1933 to 34 also agreed to the same proposals and recognized the need for setting up more than one Public Service Commission for the whole of India. Second period 1937 to 50, Government of India Act 1935. The working of the Indian Public Service Commission during 1930-36 indicates that the Commission was far from being a powerful personal agency. It was not independent of the executive. The Government of India Act 1935, under which the provinces become fully responsible, extended the statutory authority of the duties of the Civil Service Commission. With this act coming into effect in 1937, the Public Service Commission was renamed the Federal Public Service Commission. It also required the provinces to set up Public Service Commissions of their own. The chairman and other members of the commissions were to be appointed by the Governor General. The number of members of the commission, their tenure of office, conditions of service, etc. were to be determined by the Governor General. One requirement was that at least one half of the members of the commission were to be those who held office for at least 10 years under the Crown in India. The functions and responsibilities of Federal Public Service Commission were also laid down in Section 266 of the Government of India Act 1935, many of which were later incorporated in the Constitution of India. It was the first time then that these functions were given a statutory sanction. The Commission was required to conduct examinations for appointment to the services. It was also required to advise the government A. on all matters relating to the method of recruitment of the civil services and for the civil posts. On the principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another, and on the suitability of the candidates for such appointment, promotion or transfers. C. on all disciplinary matters affecting a person serving in civil capacity. D. matters relating to any claim for reimbursement of expenses incurred, if any, by a government servant is defending legal proceedings levied against him for acts done in performance of his duties. And E. questions of award of pension for injuries sustained by a government servant in a civil capacity, and any other matter referred to the Commission by the Governor General. Third period 1950 till date. The Federal Service Commission continued to function in its present form between 1947 and 1950. This was finally replaced by the Union Public Service Commission after the new Constitution of India came into force on 26 January 1950. India's independence ushered in a new era in certain respects for the Union Public Service Commission. The authors of the Indian Constitution regarded the UPSC along with the judiciary and the Comptroller and Auditor General as a bulwark of democracy. They therefore not only vested it with a constitutional status but also provided elaborate safeguards for its independence to enable it to be the watchdog of the meant system of staffing. Constitution of UPSC. The Constitution of India envisages three categories of public service commissions. The Union Public Service Commission is to serve the needs of services of the Union, a Joint Public Service Commission for the services of two or more states, and a State Public Service Commission (SPSC) for the services of a state. While UPSC and SPSC are constitutional bodies, a Joint Public Service Commission is to be created by an Act of Parliament. Composition, appointment, and terms of members. The UPSC is composed of a chairman and other members of the Public Service Commission. The chairman and other members of the Public Service Commission shall be appointed by the President, and in the case of a state commission, by the Governor of the state. The Constitution does not fix the number of members of the Commission, which is left for the President to determine. One half of the members of the Commission should be persons who have held office under the Government of India or of a state at least for 10 years. The chairman and members of the UPSC hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. But a member's office may be terminated earlier if number 1 he resigns his office in writing to the President, or number 2 he is removed from office by the President. A member may be removed from office by President if he is an adjudged insolvent or engages in any paid employment outside the duties of his office, or is in the opinion of the President infirm in mind or body. He cannot be removed from office or any other ground except if the Supreme Court finds him guilty of proven misbehavior on a reference made to it by the President. The word misbehavior has been explained in the Constitution. A member shall be deemed to be guilty of misbehavior if number 1 he is interested or concerned in any contract or agreement made on behalf of the Government of India or of a state, or number 2 if he participates in any way in the profit of such contract or agreement in common with the other members of an incorporated company. Functions of the UPSC. The functions of the UPSC as specified under Article 320 of the Constitution bear resemblance to those of the Federal Public Service Commission as specified in Government of India Act 1935. These functions may be broadly classified into 3 categories, viz. Number 1 regulatory, number 2 executive, and number 3 quasi-judicial. Regulatory. Among the regulatory functions, the UPSC advises the government in matters relating to number 1 methods of recruitment, and number 2 principles to be followed in making appointments, promotion and transfer from one service to another. However, unlike the regulatory jurisdiction vested in United States Civil Service Commission (USCSC), the UPSC in India has hardly any such powers. The UPSC's jurisdiction is purely advisory. Article 323 of the Constitution merely states that it is the duty of the Commission to advise the government on all matters relating to the methods of recruitment to civil services, promotion and transfers. Thus, unlike the USCSC, the UPSC cannot make regulations on personal matters which will be binding on all government departments. Although certain functions of the UPSC are often described as being regulatory ones, but in reality they are purely advisory functions. Second, executive functions. The Commission has a specific constitutional duty of conducting examinations for appointments to the services of the Union. Under this provision, the UPSC conducts many written examinations for different categories of posts annually. Besides the holding of interviews for selection of candidates for specialized and other categories of positions, here too it may be noted that Commission's jurisdiction is narrowly restricted to gazetted officers who constitute an insignificant proportion of the total numbers of government employees. This means that the executive jurisdiction of the Commission extends to only 1.9% of the total employees of the central government. Another executive function of the UPSC is to present annually to the President a report of the work done by the Commission during the preceding year. The President is obliged to place the report before both houses of the Parliament with a memorandum explaining the cases, if any, where the advice of the Commission was not accepted and the reason for such non-acceptance. Quasi-judicial functions. The quasi-judicial jurisdiction of the UPSC is limited both in scope and extent. In fact, it has no true appellate jurisdiction. It can only advise on disciplinary actions taken against employees. According to the Constitution, the government should consult the Commission on the following matters. Number 1. All disciplinary actions affecting a government employee like censure, withholding of increments or promotion, reduction to a lower grade, compulsory retirement, removal or dismissal from services, etc. Second, claims for reimbursement for costs incurred by an employee in legal proceedings instituted against him in respect of acts done in the execution of his duty. Third, claims for the award of pension in respect of injuries sustained by an employee and any question as to the amount of any such reward. The UPSC derives its functions apart from the Constitution of India as discussed above from other sources too, like A. The laws made by the Parliament, B. Rules, regulations and orders of the executive, C. Conventions. Under Article 321 of the Constitution, the Parliament through legislation can confer additional functions on the UPSC pertaining to the services of the Union or the states. If necessary, the Parliament can place the personal system of any local authority, corporate body or public institution within the jurisdiction of the Commission. According to Article 318 and 320 of the Constitution, the central government through certain regulations and orders entrusts certain functions to the Commission. Also, the President may define from time to time through regulations the matters in which the Commission need not be consulted. The Commission also discharges certain functions which through conventions have been entrusted to it, though these are not stipulated in the Constitution. Under the Constitution, recruitment to the defense forces is beyond the purview of the Commission, as the defense service is not a part of the civil service. But since 1948, the Commission has been conducting written tests for the selection of the scientists and technicians for the pool of highly qualified scientists and technologies who are deputed to central government, scientific institutions, national laboratories, universities, etc. These functions are being discharged by the UPSC on the basis of conventions only. Limitations of the functions of the UPSC. There are certain matters which have been kept outside the scope of functions of the UPSC. These include A. The Constitution of India under Article 335 requires the government to take into consideration the claims of the members of the scheduled castes and tribes in the matter of appointment to various posts. As per Article 324, the UPSC need not be consulted as regards the extent to which the reservations are to be made for the candidates belonging to the scheduled castes and tribes. But once these conditions are determined, the Commission as a recruiting agency proceeds with the process of selection. B. The President has been empowered to make regulations excluding matters from purview of consultation with UPSC. All such regulations must be laid before each House of Parliament for approval for a period of not less than 14 days. The Parliament, if necessary, can modify or annul them. The posts, the recruitment of which does not require the advice of UPSC, include membership of or chairmanship of tribunals, commissions, high-powered committees, posts of a highly technical and administrative nature, and filling up of temporary positions where appointments are made for less than a year. Advisory role of UPSC. Though the Commission has been entrusted with important constitutional duties and functions, it has been assigned only an advisory and consultative role. Under the Government of India Act 1935, the position of the Federal Public Service Commission also was advisory in nature. It was then felt that vesting of excessive authority with the Commission would lead to its interference with the powers of the executive. The function of the UPSC is just to advise the government, and the executive is under no legal obligation to accept its advice. The basic issue that is raised is whether the Commission can effectively discharge its functions with an advisory role. Therefore, the problem is whether a Commission constituted on the limited advisory basis would command the confidence of the public and of the services to the degree which is necessary if it is to function effectively. But there is a viewpoint that Public Service Commission's role should be advisory in nature. This question was debated in the Constituent Assembly also, and the constitution makers gave an advisory role to the Commission. It may be held that under the Constitution there are certain matters regarding which the government is bound to take the advice of the Commission. Any violation of this provision would be considered unconstitutional, but the governor is under no obligation to accept the advice of the Commission. At the same time, a constitutional restraint is imposed on the non-acceptance of the Commission's advice by the introduction of a new Article 323 in the Constitution. In cases where the advice of the Commission is not accepted, the government is required by this article to lay before the Parliament a memorandum explaining the reasons for such non-acceptance. Further, in dealing with the Commission's advice, the power of ministry or department has been deliberately restricted, under which the advice cannot be rejected unless it has the approval of the Appointments Committee of the Cabinet. No action can be taken by any administrative department against the advice of the Commission unless it has the concurrence of the committee. On account of these checks, internal and external, the number of cases of non-acceptance of the Commission's advice has been negligible. Summary. The UPSC is an independent institution which has an important role to play as an impartial and expert advisor to the government in matters of administration of personnel. It occupies a very important place in our system, which assists the government to maintain an efficient and impartial public service. In India, the Government of India Act 1919 for the first time made the provision for the creation of a Public Service Commission, which was later strongly advocated in 1923 by the Lee Commission. Finally, in 1926, the Public Service Commission was constituted with mainly advisory powers. The Government of India Act 1935 categorically specified the functions of the FPSC, most of which were later incorporated in the Constitution of India. After independence, the Federal Public Service Commission was replaced by the UPSC in 1950, which was given a constitutional status. Article 320 of the Constitution specifies the functions of the UPSC, which are broadly of three types: regulatory, executive, and quasi-judicial. Apart from the Constitution, it derives its functions from the laws made by the Parliament, rules, regulations, orders of the executive, conventions. The Constitution has vested the Commission with only advisory powers. Though the government is not bound by any advice tendered by the Commission, it is mandatory to submit to the Parliament an explanatory memorandum about cases of non-acceptance. All possible steps have been taken by the Constitution makers to ensure smooth and effective functioning of the Commission without being influenced by any political pressures. In a democracy, the impartiality of the public service is very important, which can be ensured only if the Commission functions independently.